Good morning and thank you, Mr. Arbitrator. I introduce myself as Shoaib Mohammed, one of the legal counsel representing the claimant, General Granite Limited. My aims today are simply twofold. First one of those is to establish that Mighty Saltinger Group Holdings, named as the respondents, are obliged to the proceedings of this arbitral tribunal and must accept the legitimacy of the tribunal. Secondly, I aim to tender a request for joinder, namely by Abacus Engineering Limited, as the respondents and a party to these arbitral proceedings. As my first submission, I would mention some common grounds regarding the facts of the contract between the claimant and respondent, which all parties must agree. Yourself, Mr. Arbitrator, was appointed the sole arbitrator by the RGU Law School, acting as the appointing authority under the express terms of the contract. This action was done as per Article 8 of the UNCITRAL rules, which governs the appointment of arbitrators. But the question is, why are we under the UNCITRAL jurisdiction? The answer lies in Article 21 of the contract, drawn between my client and respondents, which provides for an ad hoc arbitration under UNCITRAL rules. Hence, invoking Article 1 of the UNCITRAL rules, which reads, open commas, where parties have agreed that disputes between them shall be referred under the UNCITRAL rules, then such disputes shall be settled under these rules, and these rules shall govern the arbitration. This should leave a very heavy burden of proof on the respondents should they continue in denial of the jurisdiction of this tribunal. On a further cementing note, Mighty Holdings Limited is a company incorporated in Myanmar, where the state recently granted the New York Convention 1958 the force of law on 15 July 2013. By virtue of Article 2 of the Convention, each contracting state must recognize a written arbitration agreement generated in a legal relationship and must enforce it. Article 5 of the same convention further facilitates the recognition and enforcement of any arbitral awards within the member states. Again, I would invite the respondent to demonstrate their proof if they are still in denial of the legitimacy of this tribunal. Now, having established that UNCITRAL rules are the guiding principles in this case, I now engage Article 17, Para 5 of it to lead to my second submission to request to join Abacus as a third party to the arbitration proceedings. Article 17, Para 5 of UNCITRAL rules provides the power to the tribunal to add a third person to the arbitration as a party. Mighty subcontracted all works to Abacus, and in the contract drawn up between them, it incorporated the claimant as the ultimate benefactor of the project without any prejudice. There is a case law in Cecil's Incorporation versus Morris Mechanical Incorporation, 1984, USA, whereby a subcontract incorporated the arbitration clause from the main contract. In the United States, it is a well-settled approach where one agreement may validly incorporate an arbitration clause from another document. Gary Bone also explains this point very succinctly in his book International Commercial Arbitration, that in a successive contract, the arbitration clause or agreement, as in the underlying contract, gets extended and becomes applicable. There is extensive case law on this subject where contracts which are sufficiently close in their nature and purpose are to be treated as having the same arbitration clause. An example is the award in ICC case number 5117 in 1994, in which it was held that arbitration clauses in construction contracts encompassed disputes under work orders issued pursuant to those contracts. I request the tribunal to consider Abacus as incorporating the arbitration clause from the parent contract between the claimant and Mighty, and it be added to the current proceedings to be heard at the same tribunal. As a matter of fact, Abacus is not a stranger between the dealings of my client and Mighty, and in fact has operated under the prima facie image of one entity representing both itself and Mighty. Abacus counsels is present here in the room, and we would like to hear of their common interest shared with Mighty and how Mr. Remy Twiggins was able to create the single entity image. Another point to strengthen my request is to look at the fact that in Article 7 of the contract between Mighty and Abacus, it gives the right to arbitration in the UK if there was a dispute. Now, the right to arbitration by a third party can either be exercised in Scotland, regulated by the Arbitration Act 2010, or in England, regulated by the Arbitration Act 1996. In the case law in Dubai Islamic Bank versus Payment Tech Merchant Services Incorporation 2001, where it was held that the juridical seat of an arbitration had to be fixed before the arbitration began. And in determining the appropriate jurisdiction, the court could only have regard to circumstances which predated the arbitration. In our case, this power comes from Article 35 of UNCITRAL rules, which gives the arbitrators the choice to apply the law treatment which it determines to be appropriate. Excuse me. The requirement remains that on the part of the parties that both their contract and the applicable law be interpreted in light of its commercial context. Having said that, Abacus contract dictates to be governed by Scots law, and with the claimant based in Scotland, the seat of arbitration should be rested in Scotland. I request the tribunal in joining Abacus as a party to the tribunal here at Edinburgh in the best commercial interest of all parties and in the fairest way of interpreting the applicable law provided in the contract. That completes my opening statement, and I'm ready to take questions now. Thank you.